that, I'm going to hand it over to Kate McMahon to get us started.
Well, good afternoon, everyone. It's very good to have you join us to talk in our second, I think, of our 2017 webinar series, as Micah indicated. Micah and I are going to try to sort of tag team this and talk to you about a rule that, depending on how you count it, has been either somewhere between 26 years and 45 years in the making at OSHA. So it's a very, very interesting topic, and we welcome your questions. And as Micah said, we'll try to get to all of them, but if we don't, we certainly will be available after the webinar by email if you want to reach out to us. Let me start, I think, by just taking a minute to talk about what we hope to achieve here in this webinar. This rule is, as I said, very, very long in the making, and it's a very substantial rule in terms of size and scope. In the Federal Register, the regulatory text is about 25 pages, which is pretty big for an OSHA rule, and it's over 500 pages when you count the preamble. It's very detailed, and we can't possibly achieve any level of, or cover any level of detail on the myriad of nuances of this rule in 1 hour. So what we're going to try to do is basically give you a high-level understanding of the major changes from the existing slips, trips, and falls rule, as it was commonly referred to. Talk about the focal points of this new rule, talk about the significant regulatory provisions as we see them. We want you to leave here kind of understanding what this rule does and the major changes since the longstanding existing rule that was promulgated first in 1971 as a 6A standard. And then one other sort of preliminary note, and that is OSHA's, we've looked at what OSHA says this rule does in general. And by and large, I think I agree with the agency's take on the benefits of this rule. Let me just talk about a couple of the significant ones. One, the agency points out, and I think they're right about this, that this rule overall updates the rule to reflect technological advances in the areas covered by the rule, especially in fall protection, that were not reflected in the existing rule because it obviously is decades old. So that's a good development, and we see outdated references to national consensus standards taken out, replaced with current national consensus standards where applicable, and where many of your companies, I think, are already, which many of your companies are already following. Second thing it does that is very positive in our view is, as OSHA points out, it does generally make more consistent the general industry standard with the construction standard in the area of fall protection, slips, trips, and falls generally. So that's a good thing. The third thing that OSHA points out is it is a more performance-oriented or performance-based standard compared to a specification standard, command and control. So there's additional flexibility. Now, I don't want to overstate that. Certainly this rule is filled with specification requirements that are very detailed and that you need to understand if you're not already conversant with the old standard. This new standard adopts many of those old specification requirements. But it does provide additional flexibility in the way of performance-based solutions to how you protect your workers from falls. What, in particular, I think, where we see the performance-based flexibility is what type of fall protection are you allowed to use. So that's also a good thing. And finally, and I might wrap up with this as well, but I just want to give a word on what many of you might be wondering about, which is this rule going to stay in place? Obviously, we don't know the answer to that yet. This rule was promulgated certainly, one would say in the sort of 11th hour of the Obama administration, and the rules that were promulgated that late in the Obama administration are subject to question by this new administration. Whether this one will survive intact, I suppose we have to wait and see. We don't know whether it will be peeled back, revised, stayed, or simply not enforced by the Trump administration. However, I will say that this rule, by and large, had a lot of support from industry. The update was recommended by industry, the updates that are here. It did not see the plethora of legal challenges that we typically see of OSHA rules. Those are all signs to me that this rule is going to be among the OSHA rules that may stay, by and large, intact. And so, I wouldn't place bets on it right now, but that would be what I would predict. All right. Well, why don't we get into it? Let me talk for a few minutes.
Pause for 1 second before we get started. I have a couple people telling me you're having some audio problems, and that the conference line is full. So let me have 1 second. I'm going to give you a phone number to dial into. We're going to open a second conference line. It's going to be a little bit of a kludge, but hopefully it's going to work. So I'm going to dial in myself in just a minute, and if you'll get your pencils and pens ready, I will give you a phone number that you can use to call in. If you hold on 1 second, I can give you that number. Let's try now. All right, never mind. We'll those of you who haven't been able to dial in, if you will try again in just about 1 minute, then you should be able to get in. And I guess as I'm saying this, no one can hear me that needs that. So I'm going to go ahead and send this out as chat, and we will go ahead and get started moving back on. All right, so let me give a quick introduction of us as we are getting started. My name is Micah Smith, as Kate said. I've been with the firm for a few months here, but been practicing OSHA law for a bit longer. We here have a big OSHA group at Conn Maciel Carey, and we represent clients through all parts of the inspections, investigations, and enforcement actions through OSHA, but we also focus on giving advice and counsel beforehand. So Kate has already been talking, but I'll let her introduce herself right now.
All right. Well, I'm not sure. I'm sorry about this technological problem. I don't know exactly what's happening, but I'm not going to go through what I've said already. I think many of you know me. I've been around almost as long as it's taken OSHA to promulgate this rule. So I think there's probably not a lot of time we need to spend on introductions about me. I do want to, though, just sort of recap in case those of you who have joined us in the last couple of minutes did not hear my introduction. I want to tell you that the purpose of our webinar here is not to go through every single provision of this quite substantial and robust rule that OSHA has developed and finalized, but simply to give you our take on, what this rule does, how it is different from the long-standing slips, trips, and falls rule of OSHA, the focal points, things that you ought to be looking at and aware of, and its significance, how it's different and how it remains the same. I also pointed out that I think that this rule, notwithstanding the fact that we're certain that the Trump administration will certainly take a careful look at it because of the timing of its promulgation in December, just a month before the inauguration of now President Trump. Notwithstanding that, I think that it may survive scrutiny. It generally did not receive the amount of controversy or legal challenges that many of OSHA's rules receive, and so it looks to us like it may survive intact. We have to wait and see, whether that's the case or not. I'm going to go ahead and begin. All right. So let me just give you a few minutes on background. We've lost a little time, so I'm going to really run through this quickly. Just just a point that should be sort of the landscape for this discussion. The walking working surfaces standard has been among the most frequently cited standards of OSHA in every year that OSHA issues citations for as long back as I remember. The overwhelming majority of general industry accidents stem from slips, trips, and falls. 15% of accidental deaths, that's about 345 deaths a year, come from slips, trips, and falls. Over 200,000 injuries, disabling, lost work time injuries come from slips, trips, and falls. So OSHA had a paramount interest in revising this rule to reduce the number of serious accidents that happen in workplaces every year. Some benefits to the rule, according to OSHA, and I think generally OSHA is correct in this analysis. There is a lot, with 200,000 lost work time or disabling injuries a year, that means a lot of loss of productivity. This rule is intended, anyway, to reduce the amount of lost productivity. Obviously, along with lost productivity and accidents come workers' comp claims and potential increases in insurance premiums. Hopefully, those will be stabilized if this rule is effective. Cost to train replacement workers to replace those workers who are injured and out are costs that we hope to reduce associated with implementation of this rule. And then, of course, OSHA investigations and citations and contract opportunities that are otherwise lost. I mentioned this rule was first promulgated in 1971. It was promulgated shortly after the agency came into existence, and it was promulgated under Section 6A rather than 6B of the OSHA Act, which means basically that it was simply an adoption of an existing national consensus standard or series of standards. It's been in place since then until this revision in December. There was a stop and start effort to change it in 1973, but that was withdrawn in 1976, and we're going to talk in a few minutes about sort of the history of the new effort that began in 1990 to change this rule, culminating in the final rule a couple of months ago. One important point, because this is one of the main significant revisions to this rule, prior to under the former rule, personal fall protection was not allowed, by and large, as a means to protect workers from falls. Generally, under the general industry standard, guardrails or physical barriers were required. Now, in 1984, OSHA did issue a compliance directive that allowed for personal fall fall arrest systems to be used, but only under limited circumstances where the worker was not doing this activity on a predictable or regular basis. And our slide provides, details on what that meant, but suffice it to say that it was extremely limited when fall arrest systems could be used. So employers were required to install physical barriers and or guardrails in an awful lot of places that now, under this new rule, personal fall protection systems will be able to be used. Another point, as I pointed out earlier, for those of you who heard me talking, one of the benefits that OSHA has claimed associated with this rule that I think is a credible claim is that it generally renders consistent standards that had been inconsistent. And we put a slide together that shows you the various different industry standards, the general industry, maritime, construction, steel erection standard, all of which had different thresholds for application of fall protection. Those are now, this standard now establishes unity by and large at 4 feet or above for general industry. Also, it replaces a lot of the machine or industry specific standards that require certain types or thresholds for fall protection. Now these are all incorporated into this standard, and you have one place to look rather than a whole lot of different standards in the OSHA 29 CFR regs. With that, why don't I turn it over to Micah for a couple of minutes to talk about sort of the history of this rulemaking, and then we'll really dig in and talk about the specifics of the new rule.
All right, so as Kate said, this has been quite a lengthy rulemaking, we can say that, but let me put a little perspective onto it. I like to play what happened in history, so let me give you a little bit right there. In 1990, George Bush was president. Not the last one, but the first one, George H.W. Bush. The Simpsons debuted on Fox. The demolition began on the Berlin Wall, and Iraq invaded Kuwait. Also in that year, OSHA issued their initial notice of proposed rulemaking and held a public hearing to evaluate whether the proposed rule was good or not. Then as you look at the dates here, you can see that there was a bit of a pause until 2003. In that year, George Bush was president. The second one, George W. Bush. Arnold Schwarzenegger elected governor, and oddly enough, the U.S. invaded Iraq, not for the first time, but for the second time. And in that year, OSHA reopened their rulemaking record to address some of the comments from the hearing back in 1990. So we opened it back up, and then we closed it down again for a few more years. Fast forward to the year 2010. Barack Obama is president. We have the Winter Olympics in Vancouver and the World Cup in South Africa, where we all became acquainted with the vuvuzela. You might remember that thing that sounds like a swarm of angry bees in the background of soccer games. In that year, OSHA issued their second proposed rule to update things, because as you can imagine, over 20 years, some things had changed industry-wide. There were hearings and comments solicited through the next year. OSHA took the rule back and worked on it for another 5 or 6 years before finally in October 2016 it was cleared through OMB and OIRA. The rule was published in November on November 18th, just after the election of Donald Trump, and it went into effect on January the 17th, one of the last rules to go into effect during Obama's presidency. So it's been a long time coming, and that really is reflected in the fact that the final rule took up 513 pages in the Federal Register. It is quite a work, and you can tell it took a long time to put it together. There's a lot to go through here. All right, so we've covered the background. Let's talk a little bit about some of the revisions to the rule. Because this is a substitute rule, or it's a replacement for a previous rule, it's easier to talk about this in terms of what's been replaced and what's new. So let's focus first on the changes that have been made to the rule that existed beforehand. All right, so you'll see in the first half of this slide a lot of familiar things. If you knew the old walking working services rule, you'll recognize that it applies to horizontal or vertical services on which an employee walks, works, or gains access to a work area or workplace location. It covers floors, aisles, ladders, dock boards, step bolts, roofs, ramps, stairways, scaffolds, elevated work surfaces, and walkways, and fixed ladders. Those are all things that were covered in previous iteration of the rule, but we have some new things added here, and that's going to be the rope descent systems, fall protection, training on that, and then also a requirement for inspections of surfaces and equipment.
And let me just add one point here. For all of you out there who are responsible for compliance, it really is very important to look at the regulatory text for the new additions on inspections. We're going to talk some about training, but there are inspection requirements that are throughout the rule that are new and different from what existed before. And some of those inspection requirements are at the start of every time you're going to use this particular item, like a ladder. So make sure that you are familiar with the details of when and how often, how regular inspections need to be conducted under the new rule.
And I think we may come back to that a little more. I've got a question flagged on that topic. All right, so other effects of the new rule. One of the best things that this rule does, and if you haven't picked up on it yet, you might hear it now. We're actually pretty big fans of this rule. It's a big step into the future. It makes implementation of this rule much easier, and it also gets rid of some inconsistencies. With OSHA's, since they had a standard that had been in place for more than 40 years, it had gotten a little bit old. Other standards had been updated, and so you began to see some divergence between the general industry walking working services standard and other standards. So one of the great things that this does is it makes things much more consistent between general industry and construction. It also makes it more consistent with industry standards. When you write your original standard based on a pre-1971 ANSI standard, you've got to know that ANSI is going to move ahead. They're not going to wait for OSHA to catch up. So there's been a pretty wide divergence there for quite some time. Another great thing here is that there's some flexibility. Now, not in everything. Kate and I were discussing earlier that many parts of this are sort of more like specification standards, but there are areas, particularly when it comes to personal fall protection, that there is some flexibility for employers to make good choices on what's happening there. All right, costs and benefits. I'll skip over this pretty quickly. On the one hand, OSHA's analysis shows that they think this will make a big difference in terms of cost savings for employers. We talk to employers every day. We're very familiar with the expenses side of this as you try to put in new guardrails, as you hire people to do inspections and things like that. So it's probably most likely the costs are a little underestimated. The benefits may be correct, but in response to some concerns about the cost of this rule, OSHA did use a 20-year phase-in for some parts of the rule. Most of the rule, they're leaving a year or two to phase in, but for things that are more equipment heavy, like fixed ladders over a certain amount, like for really tall fixed ladders, then there's a much longer time for compliance there. We have a list of industries affected. These are the ones that will feel the effect most. But this really is something that is going to affect every workplace. If you have an employee and they work on a surface, aka a floor, this is going to affect you at some way. All right, some other notable revisions. One of my favorite is the fact that they got rid of the section-specific definitions. Before, when you opened up 1910-21, you had to go within that standard to find the definition for fixed ladders, or you had to look under the part where it talked about the definitions for portable wood ladders. And so it was really much more difficult to use. It was much easier to accidentally look at the wrong definition. Now we have unified definitions, so that makes things a little simpler. It also eliminates overly specific application conditions. So for this, in the old standard, you had some of the rules on keeping passageways and aisles clear had some strange application language at the very beginning of it. It would say, where mechanical handling equipment is used, you have to keep aisles and passageways clear. It led to some confusion because OSHA tended to apply those rules pretty much to all workplaces because they thought, for housekeeping, you should have all of these things clear and able to access. But they had that strange language, so they've gotten rid of that. The previous standard talked about fixed industrial stairs, which always poses a little bit of a challenge in trying to define what is an industrial stair. Is it different than a regular stair? So they've gotten rid of that. Now we just have stairs. And there were also problems when they tried to require guardrails on the side of open-sided floors, platforms, and runways. It was an odd definition that could lead to some confusion on that. Another great thing here is they've combined similar equipment into the same standard. So whereas before there was a separate section for portable metal ladders and a section for portable wood ladders, now we can handle all those things together. We've put up here the overall hierarchy of the standard here. We'll switch it in just a second. You can compare to the old, but it reads much more easily. It's much easier to navigate and to find what you're looking for. Two things to highlight are the non-mandatory appendices. As OSHA often does, they will publish some non-mandatory requirements intended to be helpful. Sometimes those things are less helpful and more regulatory in the way that they're applied, so it's worth noting that those are down there. It's Appendix C and Appendix D, and they deal with the personal fall protection. All right, so here's the side-by-side. OSHA included this in their rulemaking. You can see on the left side is the new rule, on the right side is the old rule. This is what I was talking about before. On the old rule, 1910-24 was fixed industrial stairs, and now we've left that language behind, and we have 1910-25 is just stairways. So it's much easier to see that these things are more broadly applicable. Even if you're not in an industrial workplace, you still have to look at your stairways and make sure they comply. And as you look at this, you can also see that there are a couple of new provisions. So 1910, 28, 29, and 30 are really all new. OSHA managed to collapse the previous standards that had spread out over there into the lower numbers, and they added 28, 29, and 30. And there are other new parts throughout, but those are the big new ones. All right. In keeping with the streamlining, simplifying nature of this rulemaking, OSHA also did a pretty good job of getting rid of language that was confusing or some of the more arcane requirements. So under housekeeping, just the language that they use in describing what you have to do. It makes it clear. You just have to keep things clean, orderly, and sanitary. You want to keep them clean and as dry as possible. Before the rule had said something to the effect of, you should provide raised platforms and things. And the sentence describes this long narrative of how you have to do all these things. And at the very end it says, if there's a chance that the floor will be wet. And so the language is just a little bit cleaner and easier to read. Under the load limit, that's Section B of 1910-22, there is now a more clear requirement that every walking working surface can support the maximum intended load for the surface. We should flag that under that it's not found in this section of the standard, but for many surfaces, particularly things like stairs or ladders, there is a requirement that you have that the structure be suitable for 4 times the maximum intended load. So I'll flag that here, but right here under the load limit section, there is this requirement that all walking working surfaces have to be designed to support the maximum intended load. The other part under the load limit that I always found annoying, I saw too many Mickey Mouse citations issued under it, was there was this requirement that you had to have displayed a plate indicating the max load. So I represented companies that maybe they had an office with a flat roof inside the plant. They threw a couple cardboard boxes up there, which caused the COSHO to climb up, check it out. They couldn't find the nifty little metal plaque that said what the max load was, and there they had their citation under 1910-22. That requirement is gone. There are, of course, local regulatory requirements that apply to posting load limits and things like that, but no longer is OSHA going to require you to have that plaque. It doesn't mean they may not want that information. If you have things stored, a particularly heavy load on top of something, they will probably ask what the load limit is, and you should keep that documentation. But hopefully this gets rid of one of the more gotcha type sections. All right, aisles and passageways. This one's much more clear. As I mentioned earlier before, this had the application language of where mechanical handling equipment is used. Now it's clear that it is it's required all the time that you have to ensure safe means of access and egress to and from walking working surfaces. All right, then we have an inspection requirement. This is a generalized inspection requirement under 1910-22D, and this is the less onerous inspection requirement, and it's a little bit more vague, but is certainly more performance-based, that you do need to inspect as much as necessary to keep things in a safe condition. All right, moving on to some of the more specific standards here. Ladders is under 1910-23. As I mentioned before, we've collapsed fixed ladders, portable ladders, wood, and metal into one standard, so you can find it all in one place. Here are some of the more general requirements, and we should note that OSHA pays a lot of attention to these ladder standards because they account for so many of the general industry fatalities and lost time injuries. So if you have ladders in your workplace, definitely expect the COSHO, if they make it out there, to be taking a look at them. All right, so some things that are made more explicit in the standard now are ladders have to be capable of supporting the maximum intended load. Mobile ladder stands and platforms have to be able to support 4 times the maximum load. There is now an explicit requirement to have daily inspections before using a ladder. So there had been times before where OSHA was implying some kind of an inspection requirement. Is a little more vague, the source of it, because of how scattered the previous standards were. But now it is quite clear, before an employee uses a ladder during a shift, it needs to be inspected for initial use. That opens up all kinds of questions for you internally as you go about complying. And I see we have a question right now about whether daily inspections have to be documented. There's the trick. There's no requirement for documentation. But if you don't have documentation, how are you going to prove it? OSHA will come in and say, all right, did you inspect it yesterday? You say yes. And they say, well, how do you know? And what if you have an employee who tells the COSHO, I picked it up and nobody inspected it? It's a tricky compliance problem because you have to do enough to be sure that you're complying. You shouldn't create onerous documentation conditions for your employees and your managers, but it is something that you have to consider. So if you have specific questions about it, we're happy to answer them, but it is one of those tricky things that you have to figure out. All right, so now under the ladder rungs, before there was more of a specific requirement. They've opened that up. There's a range. As long as they're between 10 inches and 14 inches apart, you're okay. And then as I mentioned previously, wood and metal portable ladders can be addressed together in the same part of the standard. All right, so fixed ladder fall protection changes. This is a pretty significant change here, and it reflects a big shift in thinking about how to promote safety on fixed ladders. Before, it's also in keeping with the general move toward allowing and requiring more personal fall protection. Before, the gold standard was having ladder cages or ladder walls or wells, and so that's what OSHA believed was the best. But now in this world, we've moved on, and we've seen some of the problems that you can have with some of those ladder wells. So now there's a shift away from ladder cages, ladder wells, particularly for those fixed ladders that are higher than 24 feet. This is one of those implementation questions. OSHA's rule is now, sorry, I'm just checking to make sure we don't have this on another slide. The rule is you have to, for new fixed ladders being installed after November 2018, you have to install it with a personal fall arrest system or a ladder safety system. So new ladders installed after 2018 have to have the new system. No longer will having a ladder cage, ladder well be enough. So then there's a question, so that covers new ladders that are going in. What about existing ladders? All right. For existing ladders, there's a requirement that by November 18th, 2036, all fixed ladders have to be equipped with personal fall arrest systems or ladder safety systems. So the bad news is you do have to replace all of your fixed ladders over 24 feet, but you don't have to do it until 2036. So you have some time, but you do have to do all of that. We had a question about the requirements here of this change, what happens to fixed ladders under 24 feet. As we read the standard, it's still fine to use ladder cages, ladder wells, these other alternative things, as long as the fixed ladder is under 24 feet. It is those taller ladders where you're going to have to move to the personal systems. Now, there will always be questions about whether how you measure the ladder. If it's the top rung, I would encourage everyone to take the most conservative view of that possible. I suspect that OSHA will find a violation if possible. So certainly you've got to get it to the rungs at the top, but I would be willing to bet that if you measure to the next surface, that might get you there, or even the top of the handrail. There will be interesting challenges for compliance and some choices to be made if you have a lot of ladders and things like that. But that's something to be considered. I do want to highlight there's this is mostly for us law nerds. There's a little bit of a discrepancy in OSHA's language. The rule, it seems to us, makes it pretty clear that between now and 2018, that you don't have to do anything, that there's no new requirement until 2018. But in some of the OSHA guidance, it says that starting now, you have to start making this shift to replacements. When there's a replacement ladder or ladder section, that you have to shift over to the safety or personal fall protection system. We read this as just somebody made a typographical error. The best advice we can give is if you're replacing a part or all of a fixed ladder between now and November 2018, it's best to go ahead and put in the new system. If you're struggling to get the system up and running, then you're probably fine to wait, but let's be honest, all those ladders have to be replaced by 2036 anyway. It's a great opportunity to start making that shift. So unless you have real concerns about your ability to make that shift over to start using personal fall protection and ladder safety systems, it's definitely advisable to go ahead and start making that shift.
And just a couple of more points on ladders. A question I think came in a little bit ago that asked about when you have to do the inspections. The inspection is triggered on use, so it is not a daily inspection if you're not going to use the ladder. The language of the standard says inspection before initial use in each work shift. All right, so if that ladder is going to be used in 2 or more work shifts, then it needs to be inspected at the outset of the use of the shift where it will be used. But if it's not going to be used, then you don't need to go inspect the ladder.
All right.
One final point on ladders, just another point of, it's not a discrepancy necessarily in OSHA's language, but it's a point of confusion. OSHA uses the concept and the term grandfathering in in applying in discussing the extended deadline to the 20-year deadline for the 24 feet high ladders. And we want to just point out, we've gotten a couple questions about the fact that grandfathering doesn't mean forever, like you normally think, that you can grandfather in existing ladders. You still have to make those changes to the to the new ladder that's required by 2036. Yeah.
All right. We also had a question. What about fiberglass ladders? Well, one of the great things about how OSHA rewrote this standard is that now you don't have to turn to the section related to certain kinds of ladders. You just go to the ladder section. So the requirements for clearance, for distance between the rungs, all of those things apply to ladders, period. There's a couple of extra provisions. It notes that if you have a wooden ladder, you can't coat it in something that will obscure defects. And if you have a metal ladder, it has to be made with corrosion-resistant material. But otherwise, it doesn't really it doesn't get to the level of over-specificity that I think the previous standard was there. So if you have a ladder, look at the ladder section, and you should be able to get your question answered in the standard without too much trouble. One last question related to corrosion and ladders. OSHA didn't go into a lot of depth, certainly in the standard, about considerations related to corrosive environments or things like that. But there is the requirement there that if you have metal ladders, that they do have to be protected against corrosion as necessary. So for anyone that has a more specific question about using ladders in corrosive environments, feel free to shoot us a note afterward. All right, so we're going to move on. Those are the big changes, the big revisions. Now we're going to move on and I'll let Kate talk a little bit about the additions to the rule.
All right, so this first one is really one of the most welcome changes that we've seen in the final rule, and it is what we were talking about earlier. Here is the actual language that we've got, where we see the flexibility on the use of fall protection to protect workers from falls at heights. 1910-28B1 little 1 is where we find the ability to, employers can use the gamut of fall protection that is listed on our slide there, rather than being required to install guardrails and or some physical barrier. So that's where you find it. We've got a lot to cover, so I don't want to talk more about it than to point it out, and please feel free to call us with any questions if you want to talk about that further. Just a couple of notes. One, with the personal fall arrest systems, under the general industry standard, like the construction standard now, you are not allowed to use body belts. There is an exception for that. The exception is for where you're using, where you're working around, let's see, I think it's, let me find it. Oh yeah, where the ladder safety system is in use, you are allowed to use body belts, and that's because OSHA feels like with the lanyard restriction of 9 inches with ladder safety systems, the pressure that will be exerted, the excessive force that might be exerted when there's a fall will not be something that would be overcome a body belt. So that's an exception to the exception. Okay. Residential roofs. This is a requirement that came from the construction standard. It was not in the proposed rule, though. So this is a new one for those of you who studied the proposed rule. This basically provides an exception for residential roof employers. If you have employees on a residential roof, then you are allowed to not implement the fall protection that otherwise would be required. But this is only where you can demonstrate, and the burden is on you, that using one of the systems that you would otherwise be required to use is not feasible or creates a greater hazard. In that situation, then you are exempt from using the otherwise required fall protection. However, in lieu of using that fall protection, you've got to develop a written fall protection plan. And if you look at Section K of the requirement, you'll see the various obligations that are associated with this fall protection plan, and it's rather onerous. So if you are in the business of residential construction, you really need to think twice about whether you can, use this fall protection that's available to you, because the written plan, it requires a lot. And so, look at subsection K carefully if you find that it's not feasible to use fall protection on residential roof, in a residential roof construction setting. Also note that exception does not apply to low slope roofs, 4 to 12, vertical to horizontal. So So that's an exception, again, another exception to the exception. Okay, falling object protection. This is new, but not that onerous. The Section 1910-28C requires that employers protect workers from being hit by falling objects by using one of the following items that we've got listed there: tow boards, canopy structures, barricading the area. So there's some flexibility in how you can protect from falling objects, but you've got to have some system in place. The tow board height was adopted from the construction standard and the ANSI standard that exists, the applicable ANSI standard of 3.5 inches, and that deviates from the 4-inch requirement that you may be used to. So that's in this new rule. There is an exception for work around vehicle repair and servicing and work near assembly pits. You don't have to have a tow board of 3.5 inches. You can have a 2.5-inch tow board in that limited area of vehicle repair and assembly pits. Okay. Scaffolds and rope descent systems. What OSHA has done on the scaffolding side is they have simply adopted the requirements of 1926 subpart L, which are the construction standard for scaffolds. So nothing new here if you're used to complying with the construction standard. We had a question earlier about whether the 10-foot threshold remains in place, and it does. So just simply refer to 1926 subpart L. Hopefully most of you are very familiar with that. Rope descent systems, what the new rule does is it basically prohibits the use, I guess the way to say it is, it allows for rope descent systems, but it limits the use of those rope descent systems to under 300 feet. And that is essentially just codifying a 1991 memorandum guidance document that OSHA issued that allowed for the use of rope descent systems at 300 feet or less. So it's probably nothing new if you're in businesses where you would use those systems. We just have it now codified into the regulatory scheme. One note is that and this was the case under the guidance as well, under the regulation, you need to receive from the building owner, where you'll be using the rope descent system, in writing, affirmation that the building has the requisite anchorages that are required under the standard. So that's got to be received, and you as an employer could receive a citation if you don't have that written documentation in your files, and you've got people working on those rope descent systems. Okay, so it's 10 of 2. I'm going to try to really move through this quickly so we have at least a little bit of time for additional questions. Outdoor advertising and qualified climbers. I don't know how many of you on the line are in the business of outdoor advertising. What I want to simply point out here is that this rule essentially phases out the exception, the longstanding exception that has been applicable to the outdoor advertising industry for the use of fall protection in the way of protection on ladders. In particular, OSHA allowed, pursuant to a 1991 variance that was then in 1993 applied to the entire industry, outdoor advertising industry, a variance that allowed you to avoid those fall protection requirements if you had qualified climbers. What OSHA is doing here is they are phasing out over a 2-year period the use of the qualified climber exemption. So within 2 years of the date of this rule, you will need to have the fixed ladder fall protection, comply with the fixed ladder fall protection requirements that are in the standard. Okay, training. Listen, we put this slide up because I expect that in the area of inspections and in the area of training, OSHA is going to, as you know, when OSHA rolls out a rule, there's a sort of a amped up level of enforcement after the effective dates to make sure people know that this rule is out there. Now, sometimes there's some enforcement discretion that is given either on the national level or by area offices when a rule is new, but they also make an effort to make sure that people know it's out there, and the way they do that is they issue citations. In particular, the area of training and inspections are prone to receive citations. So make sure you're familiar with the training requirements under the standard. The training requirements generally are essentially, they're performance-based. There isn't a specification for exactly what training has to be done, but you have to simply ensure that your workers who are using fall protection or working in high hazard areas are trained and retrained. There's a specific and explicit requirement for retraining as needed about fall hazards, about the equipment, and about how to use, maintain, and store your fall protection equipment. It's pretty simple, but it's a really critical part of the rule. A new piece to this is the training must be by a qualified person. And the rule defines a qualified person, and it's a person that's either certified or has substantial experience in the area. There's a specific definition. You've got a person who, by possession or of a recognized degree, certificate, or professional standing, or who by extensive knowledge, training, and experience has successfully demonstrated the ability to solve or resolve problems relating to the subject matter. So it can't be it might not necessarily be your safety director who can do this. That safety director might not be a qualified person according to the standard that OSHA has set forth here. So you need to make sure that training is done by someone who is qualified. Some of the training requirements here certainly overlap with the PPE standard in 1910-132, but the training that you do under that standard that is consistent with this standard will put you in compliance with both of those training requirements. All right, what else do we have? So we want to just talk about a couple of other things that didn't really fit into any particular category. So let's go through this. This slide just tells you what we're going to talk about. Go ahead and go to rolling stock. I believe that many of you on the telephone today are in the grain industry, in industries where you have rolling stock, and those of you who are in those industries, I'm sure we're following this rule very carefully. OSHA, I think, very seriously considered requiring fall protection for rolling stock in rolling stock situations. Ultimately, this rule does not add additional fall protection requirements for rolling stock, and that is a significant and probably, I would say, unexpected and probably welcome development for industry. What this rule basically does is it codifies the Miles memo that many of you are familiar with. Essentially, in a nutshell, there is not a requirement to use fall protection on rolling stock or motor vehicles that are not adjacent to or next to a permanent structure, like an elevator. So if you've got rolling stock down the track from an elevator, you don't have to, I guess we should go to the next slide. You don't have to have fall protection. If it is next to the elevator, as the 1996 enforcement memo indicates, you've got to have fall protection. This was a very controversial part of the rule. Ultimately, OSHA decided, as I indicated, to not add additional requirements. However, the agency did put us on notice that it is continuing to consider this issue. There is now available something that was not available in the past, which is fall protection that is sort of essentially standalone, where you could, at least in some situations, arguably there would be fall protection that would be available to on a rail car that is down the track and away from the elevator. So OSHA is aware of that. OSHA may ultimately determine that it is feasible to have fall protection down the track on rolling stock. So we need to watch this carefully. Now, I have to say the likelihood of this new administration adding a requirement is not high. However, watch carefully for any developments. The agency said that if they do develop an additional rule, they will do it as a standalone rule that addresses rolling stock and motor vehicles. Agricultural operations, the point of the slide simply is that ag operations are not covered by the rule, at least traditional agricultural operations, but look at the list under bullet number 2 of operations that are associated with the agricultural industry that are covered, including, for instance, grain handling. So be aware that just because you're in the industry generally, it doesn't necessarily mean that this rule does not cover you. State plan implementation, just want to point out here that, of course, we've got, about half the states that follow federal OSHA, and about half the states have state-approved plans. Under the law, OSHA state states have 6 months from the date of publication of a final rule by federal OSHA to adopt comparable amendments. Now, if the state can demonstrate that the program that they have existing and in place is at least as effective or more stringent than the new federal law, federal regulation, then they don't have to do anything. But for those of you operating in state plan states, note that right now you probably do not have this new rule in place, but within 6 months the state will likely, most states will likely simply adopt this, into their state code. Okay, rollout effect and effective dates. Most of the provisions took effect as of mid-January. January 17th was the effective date for compliance with most of the provisions. However, OSHA provided an extended rollout for certain activities and requirements under the rule. For instance, the agency provided until May of this year, 3 more months, to do the training that I pointed out is new to the rule on fall hazards. And you also have the extended May deadline for compliance with the training requirements on the fall protection equipment. The certification for permanent anchorages under the rope descent systems provision is not effective until November of this year. Similarly, the installation of personal fall arrest or ladder safety systems on the new or replaced fixed ladders, like Micah was explaining, you've got until November of 2018 to comply with that requirement, so a couple of years that OSHA has given. The equipment, existing fixed ladders, the large ladders, 24 feet and above, including, by the way, the outdoor advertising. Remember, we've got to equip those with the cage, the well, the fall arrest system, or the ladder safety system. We've got 2 years. And then, of course, that very extended 20-year rollout for the replacement of the cages and wells with fall protection systems on the ladders, the 24-foot and higher ladders. You've got until 2036, but as Micah pointed out, if you're replacing those, prudence would suggest that, and it might be cost efficient to go ahead and put those systems in place sooner rather than later. Just a word on where we are, because we're over our time limit here, in terms of the what's going to happen with this rule. As I indicated at the beginning, this rule did not receive the plethora of legal challenges that typically accompanies OSHA rule of significance and broad scope like this one. It did receive a couple of legal challenges. A couple of petitions for review were filed in various circuit courts. They'll be likely consolidated, I think, in the 7th Circuit. But those deal with specific and discrete provisions of the rule. In particular, the window washing industry has challenged the 300-foot limit that is placed on the use of rope descent systems, and the chimney sweep entity has challenged a certain aspect of the rule that it believes prohibits it from allowing the chimney sweepers to actually carry their hook ladders up the chimney to do their work. So, we'll see how those challenges come out. There may be some negotiation that the agency does, and there may be some settlement agreements or full-out challenges. But even if those challenges go forward, and even if successful, they will not change the huge bulk of this rule. So what that tells me is we're not going to see activity on the judicial side that will undo this rule. So it will remain in place until and unless the Trump administration decides that it is too onerous. And as I said at the outset, and what I'd like to end with is, it seems to me that of the various rules that OSHA has promulgated under in the last year of the Obama administration, this one seemed to be the least controversial from industry standpoint. By and large, it was welcomed in a lot of ways by industry. And I think that suggests that the Trump administration is unlikely to significantly undo this rule or stay it indefinitely. So, like I said, we'll see what really happens, but that's our prediction. I know we're past time. It may be that the best way to proceed here on additional questions would be, we're around now. You can feel free to call us right now, or you can email us. We will get back to you promptly. As Micah said at the outset, we're going to supply the slides as well as a copy of this recording imminently, maybe this afternoon or in the next day or two.
So what we might do, I know I have a few more minutes. We'll give you the final spiel, and then for those of you who haven't raised questions, you can sign off when you're ready. There are a couple easy questions I think we can answer for some people in the next 5 or 10 minutes. There are so many questions we can't answer all of them, but we're going to try to take some of the easy pickings. So up here right now, you can see our 2017 webinar series. Please join us again. Hopefully some of these things are hot button issues for you. If you have other questions that aren't on here, let us know. We might be able to give you some advice personally, or you might give us a great idea for another webinar. Also, keep up with our blog. It's the OSHA Defense Report. That's www.oshadefensereport.com. If we don't cover one of your questions we in a webinar, we might be able to do it in a blog post. And it's always helpful to us to know what you all want to know about. Before we take any questions, I'm Micah Smith. This is Kate McMahon. There's our phone numbers and our email addresses. Do feel free to call or email us at any time if you have any questions. So for those who need to get running, feel free to jump off now. We're going to work through a few questions for those that want to stick around now for a little bit. All right, we have had several questions related to the rolling stock. Let me try to work back through there. I think Kate gave the overview of the general rule that you don't have to use fall protection on rolling stock, that is a truck or a train, if it's not right next to a structure. It has long been understood that trying to do fall protection when you have a train car or a truck in the middle of nowhere is difficult, if not impossible. But that is changing with the technology. So as the rule stands right now, there's no requirement that you do that. Though, if you have an injury, if someone falls off, or if there's some particular condition that makes it more dangerous than at other times, you could see OSHA try to issue a 581 citation. I don't know. What do you think, Kate?
Yeah, no, that's a very, very good point. The Miles memo and the existing guidance is based on the concept that protecting workers from falls on rolling rail cars or motor vehicles that aren't near a building is in fact infeasible. They concluded that. However, the agency is aware certainly that there have been technological developments, and there is a way under certain of those circumstances anyway, let's put it this way, there may be a feasible way to protect workers in that situation. If that is the case, under the particular facts of the where the car is, what fall protection might work in that setting, and there's a fall, I think we could see a general duty clause citation issued. So, the fact that there isn't a regulatory requirement does not mean that you're completely insulated from liability. It will be a very fact-specific inquiry by the agency. If no one falls, obviously, no problem. But if there's a risk of fall, I think you need to analyze what fall protection mechanisms might be feasible, notwithstanding the fact that essentially the Miles memoranda has been codified now in this regulation.
All right, we had a related question. What about military vehicles or other government vehicles? The rules are going to be the same. The difference is OSHA doesn't have the ability to issue fines in relation to citations. They can and do at times inspect federal workplaces, but there are, of course, no fines issued. So whatever we have said for general industry is also going to be the case for any federal workplace, unless there is some more specific standard. The question here was for military vehicles, and I'm not aware of any specific standard there. All right, so we had a couple questions about training and the qualification, the definition of what qualified means. Someone did flag that this is it's a pretty broad definition of qualified, that this is one of those areas where it's more performance-based standard. You are able to define who's qualified in a more flexible way. So your qualified trainer can be someone who has a recognized degree, certificate, or professional standing, right? They may be certified or may have been accredited by a safety organization, or someone who simply by knowledge, training, or experience has demonstrated the ability to resolve problems related to the issue. So if you have an old hand on site who is really good and really experienced with fall protection, you don't necessarily have to send them off for specific training or certification. They can be considered qualified. I will say that
go ahead.
It gets a little vague.
Say the same thing. Go ahead.
It's easier to convince someone's qualified if they have a certificate, right? And you'll hear this all the time from us. If you have paper, it's easier. It may be too much trouble to get paper. And if you're doing it well and safely, then you don't have to go get the paper. Is that what you were going to cover?
Exactly what I was going to say. When you're thinking about this issue from a exposure standpoint, from a liability exposure standpoint, I think OSHA COSHOs will be more suspect about the fellow who's been around the facility for 20 years and has extensive, knowledge in the area and is a safety professional, than they would be someone who even has been there much less time, but has some certificate from some outside or some outside credential. That doesn't mean that, that you need that, as Micah said, but just be aware you're more likely to be questioned and potentially draw a citation if you're using someone who's just been around a long time to do the training. And not all standards for training, as you know, require training by a qualified person. So they're going to be, I think the agency's going to be really focused on this as they roll out the enforcement of the standard.
We had a question about video training. Is a video training considered qualified?
Okay, so yeah, I think I don't think that there's no requirement that this be done in person, as long as the training is effective and done by someone that meets the standard of qualified, then you can do it by video. In fact, the developments in training are amazing that we've seen over the last decade. Interactive video training is really effective in a lot of situations, so that's certainly not barred by this standard.
All right, so flipping back toward the rolling stock, we had a question about whether OSHA considers difference between their ladder design standards and DOT standards. I assume that this question focuses on the ladders that are installed on a truck or on a train. You'll have to correct me if I'm wrong, Kate, but I believe that OSHA would not tend to dig into the specifications of the ladder on one of those pieces of equipment, because to the extent that they're covered by DOT requirements. So if DOT has specific standards for that, OSHA would stay out of that unless you parked a trailer in place and never took it on the road. I think that's my perspective there.
Yeah, I guess the question I have, and this is a question rather than an answer, so we can certainly get back to you, is what regulatory requirements exist, what DOT regulatory requirements exist for ladders, if any. If there aren't any, then OSHA probably does have jurisdiction. So I guess that's something we'd like to look into and, get back to you on.
All right. What else do we have here? Someone flagged the question here. If fall protection is in place, do you have to use it? I believe the answer is yes. Now, there is an interesting twist on that. If you have, let's say, on a ladder, what if you have a fall protection system on a fixed ladder that goes 30 feet, but you're only going to climb it 5 feet? You have to use it. This gets into one of those very, very tricky situations. I think to the extent that the question asks whether you have to use it when you're climbing up to very high points, I think the answer is pretty clearly yes. But what if you're going to use it and not to go that high and there's no risk of falling 4 feet or more?
Yeah, I think that's right. I think that OSHA the regulation doesn't, govern climbing a ladder that's, where the worker is under 4 feet. So, but if you're over that, that's where the standard is triggered. And I think the fact that you have it, what you might be getting at in this question is if you have it in place and you feel like you've done your part, but your workers aren't using it, is that good enough? And the answer there, I'd say, is no. The employer has an obligation not only to have the requisite fall protection in place, but also the obligation to ensure that its workers are using it where it is required, obviously. And as we pointed out, there may be situations where it's not required to be used, but certainly where it is required to be used, it's your job as an employer to not only have it there, but make sure it's being used by your employee. And we could spend hours talking about how you do that, and it's very difficult certainly a lot of times, and there are defenses to OSHA citations for employee misconduct, but it's a very high standard, and you have to show that you really were diligent in a lot of ways in ensuring as best you can that your workers were complying and using fall protection. We have citations all the time that our companies, our clients receive for fall protection. They have all the equipment there. They've done everything right. They've trained the workers. They, audit the workers. But, a worker decides one day, you know what, I got 5 more minutes on the job. I'm not going to put on this, my lanyard and body harness, et cetera. They go up, they fall, and, you're cited. Now, can we defend that? If your audits were done, if you did all the right training, if you were disciplining employees historically for not complying with that requirement or not using fall protection, probably so. But you got to meet a high standard. So do your best to make sure they're wearing it.
All right, we had a couple more questions about ladders. Let's see if we can hit those. One question was, how do you inspect a fixed ladder without climbing it? It's a good question. I think you would have to climb it. The inspection provisions we were talking about earlier for ladders are related to portable ladders. I was just flipping through a minute ago looking for inspection requirements on fixed ladders. I don't see one specific there, so I think that we would be looking at the more general requirement for all walking working services to inspect as necessary. So
I'm going to just interrupt here because we do have a lot. It looks like we've got numerous more questions, but we're already, past 2:15. So I think we probably need to wrap up. We're very happy to have had the time to talk to you at least on, a high level and really dig in at least on some significant parts of the rule. We're going to continue to see what OSHA does in terms of a compliance directive, see what this new administration does with this rule. We look forward to continuing to talk to a lot of you about, the nuances of the rule. Please feel free to email, call, and we had at least one question. We said we'd get back to you on that DOT question, so we'll do that. And we look forward to continuing to talk to you on this issue and maybe in some of our other CMC webinar series later this year. Thanks everyone.